We're going to be looking at H21, an act relating to the service of writs of possession. And we're going to do a walkthrough of an amendment and with Eric Fitzpatrick from Ledge Council.
Thank you.
Away, Eric.
Thank you, Representative Burdett. Good morning, everybody. Eric Fitzpatrick.
Before you go any further,
Yes.
in case anybody's watching and wondering why I'm running the meeting and not Chair Lalonde, his voice is a bit raspy today and he doesn't want to.
And this is your bill too.
Doesn't want to tax it, so. But anyway, go ahead.
Yes, thank you. Thank you. And yes, as Representative Burdett was saying, I'm here to do a walkthrough with the committee of a proposed amendment to H21, which is an act relating to service of writs of possession. As the committee probably recalls, the topic that's being dealt with here has to do with when the court issues an order, which is known as a writ of possession, and that happens when there's a dispute over the lawful possessor of property, real property. And the court makes a determination that someone is in unlawful possession of the property, and they can issue this writ called the writ of possession, which directs the sheriff to go to the party who's in unlawful possession and say, vacate the premises, turn it over to the person who should have lawful possession of the property. And that's this old legal term called a writ of possession that directs the sheriff to do this. So in existing law, the statute that governs service of writs of possession specifically says this writ has to be served by the sheriff in the county where the real property is located. So that's the issue that was trying to be addressed by H21. You may remember the idea, the concept behind it is to find a way to permit sheriffs in other counties to serve the writ sometimes. You know, that could be for logistical reasons. Maybe the lawsuit takes place in one part of Vermont, but the property is way up in another part. There could be reasons of which sheriff's department is busier than any other. There could be all kinds of reasons that might be involved in why it might be useful to have another sheriff's department have the ability to serve the writ in certain situations. So the first crack at it in H21 as introduced was to modify the writ. In other words, the order itself that the court issued. You may recall that if you're looking at the amendment now, for example, on line 12, it's not there now because that was the prior version, but the initial approach toward finding a way to do this was to say, well, the writ, the way it's written now, starting on line 11, directs the sheriff of the county in which the property or a portion thereof is located, and it said originally, comma, or the sheriff in any other county to serve the writ upon the defendant. So the idea was that it was a modification of the court order, the writ, that's where the proposed change in the statute would be, what the court does. And I think after the committee had a chance to talk about this and hear from witnesses and discuss it, it became evident that it might be better and more efficient not to have the court be involved in this as much as possible and just have the sheriffs work that out amongst themselves, depending on when it is, it might be useful or helpful for them to have a sheriff in a different county serve the writ. So that's the approach that you have in the amendment now. Other than notifying the court what's going on, it really leaves this in the discretion of the sheriffs to figure out when this situation should come up.
So does this say I guess in any instance, if one sheriff goes into another county, they have to have basically the okay from the sheriff of that county?
Only for serving of the writ in this particular type of proceeding. Nothing else at all would be affected as between the jurisdiction or authority of the sheriffs generally.
Okay.
Yeah. But you're right.
A sheriff from one county could go into another county and arrest somebody if they had to.
Well, I was just gonna say, but in this instance, we make it something that has to be done.
Yes. Right.
Okay, just this instance.
Right.
Okay.
Whatever existing authority is between how the sheriffs in different counties interact with each other in any other matter isn't affected by this. But it would apply though, if the sheriff of the county where the property is located, right? Because that's under the statute. That's right now, the way it is right now. That's the person who's got to serve it, right? So this permits, this is starting in the new language, subsection B, page 1, line 14. This permits the sheriff of the county where the property is located, and I'm on line 15 now, to designate a sheriff in another county to serve the writ. if the sheriff in the other county consents. So, you can't just designate them without telling them and say, oh, I didn't do it, but they were supposed to do it because I designated them. So they have to agree, which at least based on what I think the committee has heard in testimony, that's as a practical matter, the way things are going to work out. There are times when they'll communicate with each other and figure out when this is appropriate. So in that situation, though, what would happen is the sheriff of the county where the property is located designates a sheriff in another county to serve it. Obviously, the sheriff in the other county has to consent, and then the sheriff who made that designation has to file a copy of that designation with the court. So the court knows what's going on. The court is aware that there's a sheriff in another county who's going to serve the writ in this situation. So that's the idea. Conceptually, as I say, it's different than requiring the court to actually make any changes to the order or the writ itself. It's just an agreement that's worked out between the sheriffs, and notice has to be provided to the court. And that's the proposal.
So I guess somebody just said, why does it have to be in a law for two sheriffs just to have an agreement?
I think that it's because the law right now says, lines 11 and 12, the writ shall direct the sheriff in the county where the property is located to serve it on the defendant. That's the reason.
Does the,
Nope.
No, go ahead.
so does the writ language need to be modified to say, to direct the sheriff or their designee, to being, so that when the designated sheriff from another county serves it, they're in compliance with the writ?
Yeah, that's a good point. It might well be that you wanted to say something along the lines of,
So yeah, the writ shall direct the sheriff of the county or their designee.
or something like I was going to say, or a sheriff designated pursuant to subsection B of this section or something like that.
I don't know where it would go on that.
Right.
Yeah.
But I get the concept. That's a good point. Thank you.
Or I may be just being persnickety, and when a deputy sheriff does this, they're a designee and they're able to do it in compliance with the writ as language is right now. So maybe it's not necessary. I'm not really sure.
I don't think so. I think
Okay.
I think you cover your bases that way because of the designation is framed in terms of the sheriff also.
And then one other question. This sort of, and I'm Karen, maybe it's a question for you. So I thought that the sort of fact patterns that we were talking about were like not around the sheriffs talking to each other, and that was more like best practice, but that they wanted to let people like seek out a sheriff from another county if they weren't able to. So this sort of shifts this quite a bit to like those sheriffs working together. Yeah.
So.
Or unless I misunderstood sort of the.
If I may, it doesn't necessarily address if two sheriffs aren't willing to work together.
Uh-huh.
And so we did explore seeing how judiciary could be available to that. And I think when Judge Zonay speaks, I was going to ask that question of like, can we direct you to, and it gets really complicated,
Okay.
my understanding. So I was going to bring that up when.
So, sorry, I'm not trying, yeah.
Yeah.
Is there any provision if there's no sitting sheriff?
No, but it's an interesting question because that would be a question under existing law as well. The existing statute doesn't address that either. So I'm not sure what they do in a situation like that.
That I think was kind of my point.
Right. One thing I might add, because Henry, as I'm thinking more about your question and looking at the language, it may be you'd want what we were talking about anyway, but now that I read subsection B again, it provides notwithstanding subsection A of this section. Sheriff may designate someone else. So I think I read that as saying, even though I do read that as saying, even though sub A says the writ shall direct a sheriff in another property to do it, B says, well, notwithstanding that, despite the fact that it may designate a sheriff in another county to do it, that other sheriff can still designate a sheriff in another county to do it. And then they have to provide notice to the court. So there'll only be a question for Judge Zoney, I think, but it sort of raises the question of it may not happen when the original writ is issued. It could be not till further down the line when more facts become available to the sheriff involved, that it might occur to that sheriff, this might be a situation where I'd want to be able to designate a sheriff in another county to do this, but the writ's already been issued. So they wouldn't necessarily know. I mean, maybe the sheriffs would be able to talk about this as well, but if you don't know in the first instance, then the writ might not have said anything about, unless I suppose they could do a form. The form writ could always say something along the lines of, or a sheriff designated pursuant to, 4854B, it could incorporate it that way. But I think reading the language literally, I read the notwithstanding provision saying it's not necessarily true that you would need to put that new language in A, but it might be best practice anyway for clarity for everybody.
When there's a conflict between a statute and a court order like this, I don't know, is a writ a court order or I don't know exactly what the term is for that. But when there's a conflict between the two, the statute would take precedence.
Yes, although I don't think there is a conflict in this situation because it's notwithstanding.
It would, basically it would be like, if you didn't change it, it would say, the writ would say it's got to be the sheriff in the county where the property is. And then we're saying, well, actually it's going to be a different sheriff and we're doing it because of B.
I don't read that as a conflict, and I don't think our office does generally. Notwithstanding clauses.
Notwithstanding are not a conflict. They're like a.
Right.
Okay.
Right.
Cool.
I think if you didn't have that notwithstanding clause, and then it started, the sheriff of the county in which the property is located may designate another sheriff, then there'd be a conflict. Absolutely.
Cool.
Which sometimes happens when we forget to include in that clause. But
no, I'm definitely learning. That's
yes,
very helpful.
I appreciate that. Thank you for the comment. Yep.
Okay.
With this terminology saying sheriff, so say if it is the sheriff in one county, designates a sheriff in another county, again, if the sheriff isn't there, would that word sheriff include deputy sheriff?
I think that'd be a good question for the sheriffs themselves, because the only, how does it work under the current statute would be an interesting question.
Right.
Yeah, it currently says shall direct the sheriff of the county in which property is located to serve the writ currently. So
Right.
what do they read that as deputies?
Yeah, they do.
They do.
Figured the system was in place.
Right. Well, no, it's a good point.
Sometimes this stuff makes you think.
Yeah.
Any other questions for Eric? Thank you, Eric.
Yes, you bet. Thank you. All right.
And Judge Zone.
Good morning.
Morning.
Tom Zone, Chief Superior Judge. This is a policy decision.
Thanks for your testimony.
But I do think it's important to understand what's happening and what would happen. Currently in more than one county, my understanding is that there are delays and difficulties in having these writs served. That leads to frustration by litigants who've been waiting for a while to get their property back. It could lead to financial issues for them. And those frustrations are unfortunately oftentimes viewed as the court failing. In other words, that they're frustrated with the judicial system because they have their order and nobody will serve it, and what's going to be done. And so I think the problem, if you will, is that we want to make sure that everyone's writs are served in a timely manner. For whatever reason, in 1979, the legislature enacted a statute that said it had to be served by the sheriff of the county. I don't know why that is. I do know that currently any sheriff in any county can go to other counties and serve the initial summons, complaint, and other papers. A sheriff from one county can go and enforce the law. They have statewide law enforcement authority, and they can sign contracts to go in another county and provide law enforcement services. We use the county, and I know that, for instance, the Windsor County has contracts in Orange County, I believe, and they are the law enforcement agency there. And we also use the Windsor County sheriffs to come into Orange County to do the security in the courthouse. And so I also believe that, Representative Oliver, correct me if I'm wrong, that to if somebody likes the Chittenden County Sheriff and wants to hire them to do traffic details in Orleans County, they could do it. And they don't need, none of those situations need the permission of the sending sheriff. So this is a unique statute that says it has to be with that one sheriff. And I guess the question would be why? And the answer is, I have no idea. I don't know why that is. What I do know is that if we have a litigant who's waiting and they know that the sheriff is up running radar and working on a security detail from one county in their county, and they can't get something served, they may ask themselves, well, or ask the court, why is it that they can be here working under a contract in this county, but they can't serve my writ of possession to get me my property back when I'm losing X amount of money per month? And so H21, it's simple, direct, clear, concise language before the amendment, just said they can do it. It basically put it on stead with everything else. And so it's a policy decision whether the legislature wants to put in this additional protection where you need the authority of the sending sheriff or the home sheriff to do that. And if you're going to do that, it doesn't necessarily solve the problem if the sending sheriff is not cooperative. And so I know that there have been questions about, well, can't we add a provision? Can I jump into your, which I anticipate your question? Can we add a provision that says, well, the court will get involved? Why we need the court to get involved when something seems very simple, adding more court time? That person who's now spent how much money on legal fees to get somebody out of their apartment now has to come to court and address it there. And if we do say that the court has to get involved and make the decisions, the question I would have is the designation determined on a case-by-case basis, or can we say that, okay, this county sheriff is out? And there's delays, there's issues. What level of delay, or what are the criteria that we would employ? If we would a judge say, well, I think in one county say, I think if you don't serve something in 3 days, I'm going to designate someone else. Or another judge might say, well, a week's okay. So we need to know that. Does the sheriff in the county that might, if you will, lose the business, does he or she get notified of this hearing so they can come and tell the court what they think the facts are and whether they can handle the job? And does the other party, the defendant, get a hearing, get a chance to get notified to come in and weigh in on this? Because it is a lawsuit and they're a party to the case and they're supposed to get notice. And so the other issue would be, if we're going to go in this direction, I think the party who's seeking the writ should have to come in and tell us who they want to be designated. We can't just designate no one. So we have to know, here's who I want designated. So we have to jump through all these hoops. And this results in increased filings with the court, increased hearings, and increased costs. That's the impact of that if you go in that direction. If you are going to have a provision that says what this draft 1.1 says, I would also note that sheriffs generally don't file things with the court. They should provide it to the attorney for the plaintiff or the self-represented plaintiff, and then have it sent to the court through them. But again, it's a policy decision, and that first draft seemed pretty simple and direct.
That was going to be my question, but go ahead, Karen.
That was my question too, is so, you answer it. So if either of these work for you, if we go with the amendment, it sounds like there might be some tweaking as far as where the filing would go or how that's navigated, but you see the original draft could work.
The original draft is simple. It puts service of this document on par with service of other documents and other relationships, between the inter-county actions with law enforcement.
So maybe it's just hearing from the sheriffs then of, now with these two options and hearing from you, where do we go?
Frankly, my thought is you want to cut down on court filings. And if you went with the option that had the designation, the way it's phrased, the court would not know who to designate until after the first writ is served, is issued. Because then you get the writ issued, and then you have to go after the writ's issued and say, okay, before it's served, you have to say who's designated. Well, if we have to go back in and change the language, you can tell the plaintiff to go prepare that new writ. And they prepare that, and that attorney is going to come back in to say, hey, judge, here's who it's going to be. And that costs time and money. It builds in more delays.
Yep, go ahead. Karen, were you done?
Yeah.
Okay, Ian?
Do sheriffs have, there's probably conflict of interest, situations for sheriffs. I don't really know what their rules are around that. But, I'm just thinking of a situation where, if there was a conflict of interest for a sheriff to serve a writ, would designating a sheriff, like, would the conflict of interest move to a designee if there was one, and would that prevent another sheriff from serving it? Does my question make sense?
It does. Generally, if you have a conflict of interest, it's your conflict.
Okay.
Your question also, I think, fairly gives rise to something. If we look at it, for instance, with a judge recusal, what the rule that I believe judges should employ and that our judges need to employ is that if you are recusing yourself from the case, you don't decide who gets the case. You get out, and if you're not supposed to be in the case, you don't touch the case. It falls to another judge, presiding judge, or myself to get involved if necessary to decide who gets it. And so I don't know about conflicts of interest. I'm sure the sheriffs can have their opinions on that.
I see head shaking up there, so, yeah.
Yes or no? Are they agreeing with me or not? We'll see.
I'm sure Sheriff Gamlin is gonna address this.
Yeah, so I would ask the sheriffs, I just know with judges, if a judge has a conflict of interest, I tell them, you don't decide who gets it.
Yeah.
Because what's the perception of the person? Oh yeah, that judge can't hear it, but he's deciding or she's deciding who's going to hear it.
Yeah.
And I just like to think that we should avoid that type of appearance in the judiciary.
Yeah. Thank you.
Any other questions?
Going once. Thank you, Judge.
Thank you.
Sheriff Gamlin,
Yes.
you are up next.
Hi.
And if you want to introduce yourself and jump right into a comment on the conflict that we're discussing right now, feel free.
Daniel Gamlin, Sheriff of Chittenden County. The conflict interest, that's why we have deputies for. If I don't feel comfortable serving or executing a court order, personally, if somebody I know, I have a deputy to do that. So I don't think that's going to be an issue in any sheriff's office.
Great. And did you want to continue your testimony?
So I think that the writ of possession, if I have no interest in going into somebody's county to do their work, literally do not. I got plenty of work, like I said last week, in Chittenden County that I have no interest going into Franklin, Addison. But if an attorney is having an issue with a certain sheriff's office because they're not getting their work done, including a writ of possession, I think an attorney should have a plan that they can go to have that document served. And also the execution of the writ of possession. So if Chittenden County went up to Franklin County and served a writ, does Chittenden County have to execute that court order if they refuse to move and we're the ones that are going to do the vacate? Or can Franklin County, for an example, go into their county if it was served by me to execute that court order? Because I believe the way the statute is now, it's the sheriff of the county, and he's the one to turn over the property, he or she, to the plaintiff. So there's the execution part of this also. Not just serving it, but executing the court order.
Yeah, go ahead, Karen.
Yeah, I don't think I'm following fully. So maybe so we're talking about serving the writ. And it sounds like there's another step after that.
There is.
That's not clarified in this legislation, but you're saying what we do in this legislation could impact that next step.
Correct.
Okay.
Because the sheriff can serve the writ, but 60–70% of the time after the writ is served, the tenant doesn't move, so that sheriff has to execute that court order. So if I get designated to go up to Franklin County and serve, an example, a writ of possession, does the Chittenden County Sheriff have to execute that order, or can Franklin County execute that order?
And when you say execute the order, that isn't necessarily immediately, like right after you
No,
serve
no,
it.
there's
Yeah.
a 7-day and a 14-day writ, yes.
Okay, so I don't know if the judge is able to share. I don't know. This is way out of my
Yeah.
content. Have you heard the question? Okay. Do you have any info you can help us with?
I think it's an interesting issue. Generally, it would seem that the officer, the sheriff who serves the writ is usually, in my experience, would be obviously under the statute, is the one who would enforce the writ that they serve. And so it would seem to me that if the Chittenden County Sheriff served the writ, that the Chittenden County Sheriffs would be the ones who would enforce the writ. But I haven't done any research on that. But again, it just seems to me that the act of serving the writ, you're giving persons notice that if you don't do something in a certain period of time and leave, the sheriff who serves the writ is going to come back and address it. So it would seem to me that whoever serves the writ would be the ones responsible for enforcing the writ. But again, I that's just in practice, and I'd have to do some more research, and other judges could potentially see that differently. That's a quick read.
So I guess, Sheriff, with that understanding of it, does that impact your support of this? Or it would just impact your maybe decision of if you take on these service? Because you're like, oh, well, each one I take on, I'm gonna have to also execute.
Yes. I mean, I personally, if I'm going to serve it, I'm going to execute it.
And if I may.
Yeah.
Sure. So we have the bill that was introduced last week, and then we have this amendment to it. We heard from Judge Zone that could potentially go with either, but the original that we introduced works. Do you have a preference or any thoughts on either version?
Honestly, I do not. I think attorneys who practice in landlord tenant, I think should have some type of opinion on this, honestly, because they're the ones that are calling my office saying such and such county is not getting this done, and can you do it? And obviously they know, or they call and complain to me, and they know I can't do it, but they're airing their frustration. So I think attorneys should have an opinion in this, how this language should be written, honestly.
Thank you, Jeff.
Is there a site for who can execute a writ of possession?
It's in the actual writ of possession as is written today. It's the sheriff of the county is to turn over the property to the plaintiff.
So the way I read 4854 as it is currently, what we're talking about is just the service of the writ, not the execution of the writ.
Right.
I believe probably what the sheriff is referring to is further down that same sentence that we defined into the amendment.
Oh, wow.
So if the first part says, shall direct the sheriff of the county to serve the writ upon the defendant and not earlier than 14 days after the writ is served, put the plaintiff into possession. So I think the sheriff's probably referring to that second part, the execution has to happen, at least 14 days after the writ is served. And I think.
So if we went back to, and I guess it's a question for counsel, so we went back to the earlier version of this bill by saying any sheriff of any other county, that would relate to both the service of the writ and execution.
Thinking the exact same.
Yes.
I agree.
I don't know with your fancy dancy notwithstanding clause, if that would that also be the case with the designee in the new version?
I would say that if, in other words, if we went with option B, if we went with the amendment today rather than the original language.
Yeah.
I think you might, to be clear, want to make a slight change to that, to say something like in line 16.
Yeah.
To serve and execute the writ.
Yeah, yeah, because I think if you, in how I read me right now, you would be able to execute the writ, but then the sheriff of the county where the property is would have to, or you'd have to be able to serve the writ with a designee, but you'd have to execute the writ with the county sheriff.
I agree.
I think I know the answer to this. But I'll ask anyway. Is it a concern of yours that if it's being neglected so much in one place that you're gonna be the go-to for all of them? And is that another issue in and amongst itself, something you can work out with the other sheriff? I do understand that most of the time, most of the sheriffs, it's gonna be okay if there's a conflict or the person who needs to be served is outside of the county and from which the writ was issued, like the circumstance from Brattleboro to the Chittenden Regional Correctional Facility, for instance. But that would be a very common problem. And I think the sheriffs would agree to do that just automatically, really, right? But are you worried about becoming the Franklin County process server, I guess?
Yes. I mean, if they cannot get something done in Franklin County and they reach out to our office to help, I think there should be some type of language where we're able to do that for them, because it's the attorney and their clients that get frustrated. I couldn't care less if I went up to Franklin County and served a writ of possession and then enforced it. Like I said, I got enough to do here that I don't need to be going up there. But you look at the frustration from an attorney and their client, and when they reach out, so I have no interest in going up there and doing their work or in any other county. I really don't. But they have a backup plan if it doesn't work out for them with that sheriff's office. That's what I think these attorneys are looking for, some type of backup plan that the sheriff of another county can go serve and enforce an eviction order, the writ of possession.
So just to clarify, would be helpful with that. It wouldn't require you to, it would just give the option and you could decline any of the requests.
Absolutely.
Okay, so you would not become the processor for another county.
Correct.
Okay, I just want to make sure it's clear on.
But certainly willing and wanting to help somebody out that genuinely needs a hand. I would assume. Any other questions for the sheriff? Thank you, Sheriff Gamble.
You're welcome. Thank you.
I think Sheriff Anderson is up there.
Good morning.
Morning, Mark.
Thank you, Mr. Chair, members of the committee. For the record, Mark Anderson. I'm president of Vermont Sheriff's Association and the Sheriff of Windham County. I have reviewed the draft, and so I'll answer the question of preference first. I'm agnostic. I don't know it's necessarily the silver bullet solution in the draft versus in the original. And so this is kind of the 10-month problem that we've all been kicking around, where we've said we would like to find a way to do this and we just can't find the path. Where the sheriffs began our work on this issue was in Title 24, Section 293, which encompasses the sheriff's duties and says the sheriff so commissioned and sworn shall serve and execute lawful writs. The issue that the statute that the committee is considering the change to is that this really dials into this writ of possession issue. And so you've heard about heard about how the law enforcement authority is statewide. We can serve other forms of civil process or court orders statewide. But with the writ of possession, we have a codified process or procedure. So broadly, the sheriffs don't have an issue with having the statewide jurisdiction. It's that we don't want to upset the complexities, and Judge Zone testified to this earlier. We don't want to upset the complexities of how these things work. With regard to who's executing the writ, not a disagreement with Sheriff Gamlin. I'm just presenting the one scenario that was brought up in testimony before. If a person's incarcerated in Chittenden and it says, or it makes sense for the Bennington County Sheriff to send the writ to the Chittenden County Sheriff to be served, I don't know that it would make logical sense for the Chittenden County Sheriff to drive to Bennington to then enforce the writ. So I can see different constructs playing out in different scenarios. Generally speaking, I think where we're coming from is saying we don't want there to be single points of failure, which is how we've approached this bill and this work, is to say, how do we not have single points of failure, but how do we also not upset where it's working? So I don't know that I provide clarity or a solution necessarily to the draft or to any of the testimony you've heard before, but I'm happy to answer any questions.
Thank you for that. And so again, just to clarify, what I'm hearing is could go either way. Is that correct?
That is correct. I'm not sure that either way is the better way. It's just a way. Yes,
Okay.
ma'am.
And then I also heard from Sheriff Gamlin of having input from attorneys that deal with these issues would be helpful. And I know that we got that input on the initial draft, that they were supportive of it. So I'm leaning towards just going towards the original. And that seems like that would work from your perspective.
Again,
For now,
I think it works. I think there's an opportunity, and I know you're on a deadline, so I think it's an opportunity where more discussions can be had, but the Sheriff's Association does not oppose the original bill. We just think there might be opportunities for improvement that we have yet to find.
Great.
Hey, Sheriff. Quick question. Would you want us, if we went back to the original draft, which would be my preference, would you want us to try to put some language in here to clarify that the writ could be executed by a different sheriff's office?
Let me pull the original draft up. Would we want clarification that it would allow another sheriff to do it? I think we wouldn't need it in the original draft because it basically says any sheriff can now do this statewide. So that is simpler. The issue that we have is that I could then see it become an attorney says we're just not going to call the sheriff of fill in the blank county because we just don't like working with them.
I think that would be a potential consequence of the first draft. I think the way I read first draft is that the writ shall direct the sheriff of, the county in which property is in, or the sheriff of any other county to serve the writ upon defendant and not earlier than 14 days after it is served to put the plaintiff into possession. So I'm sort of reading that as it's still all one sheriff. And maybe I'm not.
So
it could be any sheriff, but it's one. It's like they're doing both. See what I mean? Yeah. And that's my question.
You're making that interpretation. So the question being, is this? There's a question before. Is this clear enough that it could be a deputy sheriff? And I think statutes that enable deputy sheriffs under Title 24 would address those things. So I don't see it having to be the same person every time. Certainly that I think would be something I defer to legal counsel on their assessment of. But as a matter of practice, it's usually one person because we usually have one person doing the work. So I'm not sure we've explored that. The issue in the original draft that we wanted to acknowledge, though, is that in saying that it can be any sheriff, it does provide an opportunity that removes the responsibility from a sheriff performing their duties. So we do want to call that out, that if a sheriff were to say, I'm absolutely not doing this because I don't like it, we don't want, we want other statutes to be able to cover that, as opposed to absolve the sheriff of their obligations and their duties.
Again, just here, like, this works for right now, and that we could revisit it at some point. The other body would also have it, they could do it, but that this is a good starting point to make this shift.
Yes.
You touched on the original language.
Yes. Trying to get us to move forward.
Yeah. No, I agree. I agree. The original language is gonna get the job done. Why complicate it?
If we're talking about the original language, can I plug my suggestion from last time of, if you're looking at that original language, on line 18, just removing in which the property or portion thereof is located, or the sheriffs of any other county, remove all that language and just write, and just say, the writ shall direct the sheriff of any county to serve. And that way you just remove the language around property altogether, because if we're not saying it has to be served by the sheriff of the county where the property is located, why are we including that?
That is not a question for me.
Mark, you can't see me, but I'm looking at you.
Yeah.
And as I was looking at the judge out of the corner of my eye also, so.
If the committee's to consider that, that suggestion, I'm looking at this just thinking in my own way, similar to that line of thought. Line 18 says, shall direct the sheriff of the county, yada, yada, yada. What if we just deleted after the word sheriff on line 18 all the way to down to 19 where it says to serve the writ, and just said shall direct the sheriff to serve the writ upon the defendant? Does that accomplish the same thing? Does that simplify this even more?
I don't want to testify, but I think I would really feel more comfortable if we clarified that it was of any county. So we're really close to each other. So I would say basically we're moving everything after county. So it would say the writ shall direct the sheriff of any county to serve the writ upon. And that way you're clarifying, because if you just had the sheriff, then I think there could be, it could be vague. At least that's how I would look at it.
Does Ian's language work for you, Mark?
I think that makes sense,
Okay.
with the same caveats we've already said. But again, this is progress forward.
Okay, great.
Do you want to put, all right, cool. As on record, I agree. That's just like my own personal.
And the council agrees too.
There's a lot of head shaking yes here on that amendment, so. Any other questions for Mark? I guess not. Thank you very much.
Thank you for your time today, and good luck.
Ask a process
I
question.
don't know how to take that, good luck.
Ask a process question.
Sure.
I don't know which chair I'm stating this to.
It's 21, go ahead.
Is, so I'm hearing we have this small language amendment that we are going to make to this. So I can't remember what the timeline is. Is the plan that we were going to vote on it tomorrow? Or I just want to have that concept and also put on chat.
We do have possible votes tomorrow at 11 o'clock.
I guess I would ask, do you think we're ready for that, for voting?
I think we are. Yeah, I think we are. I mean, the last question is Ian's amendment and no other.
I think if I may.
Yeah.
I think the only thing that's outstanding based on what we've heard is that I read it, even with the change that we would make with my suggestion, that right now the language would sort of direct one sheriff to both serve the writ of possession and execute the writ of possession. And that would be, do you read it differently?
No, I just had a thought, if I can.
Yeah, please.
This actually is a question for one of the sheriffs. In the circumstance that you described, in order to have what I would call a common sense efficiency between the Brattleboro and Chittenden situation, couldn't the sheriff who served it designate the other sheriff for their county to do the next step? In other words, in that very infrequent circumstance, couldn't there be a designation? So that it really is the same sheriff doing it?
This does exist currently in the context that I can deputize Sheriff Gamlin as a Windham County deputy sheriff to serve someone in Chittenden County. So that process already exists. We just have to file the commission with the court.
That's what I mean. And you would deputize him to do that one act, and then your office would still be able to do the rest of it down there.
That's correct.
Okay. Thank you. And in that case, then I wouldn't want to muck around trying to, if there's an existing way to make sure that that instance can be done legally, great.
Yeah, Tom's got.
Any sheriff serve and execute, or you could separate it there.
Are we in committee discussion? Or-
Yes.
Okay. So I think what we're saying now is that it would be any sheriff can serve the writ, and then that same sheriff, but that sheriff could be from anywhere, would also need to execute the writ. In the circumstance that we heard where it was the service was in Chittenden County, but then the writ was being executed in Windham County, we can protect against that being illegal or not compliant with the writ by designating the sheriff to execute it. And so that prevents us having to do some weird word salad to try to get us into a place where we're allowed, which I think is much better than.
Okay.
That's at least how I understood.
It's gonna add hoops to the process, that's all. I don't know.
Well, I don't know how often that happens.
And it can also be reviewed further in the other body. And this is step one.
We can't get it perfect here, though.
Any other questions or comments or discussion? Thank you again. Yeah.
Adjourn till 1?
Yeah.